Life throws curveballs, doesn't it? One minute you're focused on work, the next you're navigating a major family or health situation. It can feel like an impossible balancing act.
Yeah, totally.
That's precisely where the Family and Medical Leave Act, or FMLA, steps in. It's, a cornerstone of U.S. employment law designed to provide some much-needed support during those critical times.
And in this deep dive, we're going right to the source document, the official legal text. It's found in the Electronic Code of Federal Regulations, specifically 29 CFR Part 825.
Right.
Think of this as us handing you the Cliff's Notes, basically, to understanding the core of this law.
Our goal today is pretty straightforward. Just distill the most essential elements from this official regulation. We want to equip you with a clear understanding of, your rights as an employee and what your employer's obligations are under FMLA. It's about getting you the practical knowledge you need without, getting lost in all the legal complexities. So let's dive in.
Okay, let's begin by looking at the fundamental reason FMLA was even created. It was enacted back in 1993, and its primary aim was really to help employees manage the often conflicting demands of work and family life.
Right. And digging into the eCFR, specifically, Section 825.101, we see three key intentions driving this law. First, it's about fostering, family stability and economic security.
Crucial.
Second, it's about ensuring employees have the right to take reasonable medical leave. And third, it's about finding a balance between the needs of the workplace and the genuine needs of families.
It's acknowledging that these aren't separate worlds, right?
Exactly. So, at its heart, FMLA recognizes that life happens and, employees shouldn't have to choose between their job and their family's well-being. Now, who exactly qualifies for this protection? Employee eligibility is crucial, and the eCFR, Section 825.110, clearly outlines the criteria an employee must meet. There are three main requirements.
Okay, let's break down who gets these protections. It seems important.
Yeah, first, the employee needs to work for what's called a covered employer.
This includes private companies with 50 or more employees within a 75-mile radius.
50, got it.
It also covers all public sector employers, regardless of size, and, interestingly, both public and private elementary and secondary schools.
Schools too. Okay.
So it covers a significant portion of the workforce.
So it's not just the really massive corporations then?
Precisely. The second condition is that the employee must have been employed by the company for at least 12 months.
12 months.
Now, these 12 months don't have to be continuous.
Oh, okay.
However, if there's a break in service of 7 years or more, previous employment might not count unless the break was due to military service or there was a written agreement in place.
That makes sense, acknowledging people might have career breaks, right? And the final requirement for eligibility.
The last one is that the employee must have worked at least 12,250 hours during the 12 months immediately preceding the start of the leave.
1,250 hours in the last year.
Yep. So it's not just about how long you've been with the company, but also about a recent commitment of working hours. In essence, when you're figuring out eligibility, remember it's about the size of the company, the employee's time there, and their recent work hours.
Okay, so those are the hoops an employee needs to jump through, so to speak. Now, what are the specific situations that actually allow an employee to take FMLA leave?
Good question. eCFR 825.112 spells out the 6 qualifying reasons. The first 2 relate to welcoming a new child, the birth of a child and bonding with that newborn, and the placement of a child with the employee for adoption or foster care. These provisions recognize, that critical need for parents to have time.
Absolutely, vital times for families.
Yeah.
What other circumstances qualify for FMLA leave?
Okay, the third reason is to care for a spouse, child, or parent who is suffering from a serious health condition.
Right, the family care aspect.
Exactly. This highlights the law's recognition that employees often need to support close family members. The fourth reason is if the employee themselves has a serious health condition that prevents them from performing the essential functions of their job.
Ah, so your own health too.
Yes. So if you're seriously ill and unable to work, FMLA can provide that job protection.
It's good to know that self-care in serious situations is covered. And the final 2 reasons.
The fifth qualifying reason is for a qualifying exigency arising from the military deployment of a spouse, son, daughter, or parent. This acknowledges the unique challenges, the logistical needs that can pop up from military families.
Right, deployment support.
And the sixth and final reason is military caregiver leave. This allows an eligible employee to take up to 26 work weeks of leave to care for a covered service member who has a serious injury or illness.
26 weeks? Wow. That's significant.
It is. It's a specific provision recognizing the profound needs there. It's interesting to see how FMLA tries to cover a wide spectrum of significant life events.
It really does seem to. Now, when we think of taking leave, we often picture taking a continuous block of time off, weeks, maybe months. But can FMLA leave be used in a more flexible way?
Yes, absolutely. And this is important. eCFR Section 825.203 addresses this. It explains that when medically necessary, FMLA leave doesn't have to be taken all at once.
Okay.
Employees can take leave intermittently, maybe a few hours here and there for ongoing treatments, for example.
Like for appointments?
Exactly.
Yeah.
Or on a reduced leave schedule, like working fewer hours each day or week. This flexibility can be, crucial for managing chronic conditions or ongoing medical needs.
That sounds incredibly helpful for employees dealing with those situations, but can an employer just, refuse these kinds of flexible leave arrangements? Say, no, it's too disruptive.
Well, the regulations state that employers cannot deny intermittent or reduced schedule leave when it is medically necessary.
Okay, so they can't just deny it.
Right. However, they do have the right to request medical certification to verify the need for this type of leave.
Makes sense.
Furthermore, as outlined in Section 825.204, the employer has the option to temporarily transfer the employee to an alternative position that can better accommodate the recurring periods of leave, provided that the position has equivalent pay and benefits. This aims to strike a balance, between the employee's need for flexibility and the employer's operational requirements.
That makes sense, a balance between supporting the employee and keeping things running. Now let's shift focus a bit to the other side of the coin. What are the key responsibilities that employers have under FMLA? This sounds like where things can get complex.
They certainly can. Employer responsibilities are quite detailed in the eCFR, and one of the most critical areas involves notice requirements. That's in Section 25.3003.301. Employers have several specific notices they are obligated to provide.
Okay.
The emphasis on these notices really reflects the law's intent to ensure both employees and employers are fully aware of their rights and obligations right from the start.
Okay, walk us through the different types of notices employers need to provide.
Sure. First, employers are required to display a general notice in the workplace, like a poster. It outlines FMLA rights and responsibilities.
So everyone sees it.
Right. Ensures basic info access. Second, if an employer has an employee handbook or other written policies about leave, they must include information about FMLA within those documents.
Integrate it into existing policies. Okay.
Third, when an employee specifically requests leave or the employer gets wind that leave might be needed, the employer has a strict 5 business day time frame to provide an eligibility notice.
5 days, that's quick.
It is. This tells the employee whether they meet the basic eligibility requirements. They also must provide a rights and responsibilities notice along with that, which details what the employee is entitled to and what their obligations are during the leave.
Okay. Eligibility and rights responsibilities. What else?
Finally, they need to issue a designation notice. This formally informs the employee whether their leave request has been approved and will be counted as FMLA leave. Missing these deadlines or giving incomplete info, that can lead to significant issues for employers.
That's a lot of boxes to check, isn't it? Why such a strong emphasis on all these different notices?
Well, these notice requirements are so critical because they ensure transparency and clear communication right from the beginning.
Okay.
By providing timely and accurate information, both sides understand their roles.
Yeah.
And interestingly, failure to comply with these notice obligations can actually result in penalties for the employer, even if the employee ultimately doesn't qualify for the leave itself.
Wow, really? Even if they weren't eligible anyway.
Yep, it underscores the importance of having solid processes in place to handle leave requests properly from the get-go.
Absolutely. Clear communication seems fundamental. What about verifying the reasons for the leave? We touched on medical certification earlier. How does that actually work?
Right, medical certification. Another crucial aspect, detailed in Section 825.305. For leave due to a serious health condition, either the employees or a family member's employers have the right to request written medical certification from a healthcare provider.
They can ask for proof, basically.
Essentially, yes. They must make this request in writing and give the employee at least 15 calendar days to provide the necessary documentation. This process helps the employer understand the medical necessity.
15 days. Okay. And what if an employer has doubts about the certification they receive?
Good question. The regulations allow employers to request recertification. Generally, though, not more frequently than every 30 days, and usually only in connection with an absence or if circumstances change significantly.
So they can't just keep asking constantly.
Correct. They also have the option to seek a second and even a third medical opinion. But, and this is important, the employer is responsible for covering the costs of these additional opinions.
Oh, the cost is on them.
Yes. It provides a mechanism for employers to ensure legitimacy while still protecting the employee's rights.
That seems like a reasonable approach. Okay, so let's say an employee takes FMLA leave, they use it, and now they're ready to return to work. What are the employer's obligations regarding their job?
Job restoration rights are very clearly defined in Section 825.212. Upon returning from FMLA leave, an employee must be reinstated to either the same position they held before the leave,
The exact same job.
or to an equivalent position.
Equivalent. What does that mean exactly?
It means a position with equivalent pay, benefits, and other terms and conditions of employment. That includes things like responsibilities, duties, and level of authority. The key takeaway is that the employee should be able to return to a role that is substantially the same as the one they left.
So they can't be put in a lower paying role or one with significantly fewer responsibilities just because they took leave.
Correct. Furthermore, the regulations explicitly state that employers cannot use the fact that an employee took FMLA leave as a basis for any adverse employment actions.
Like demotion or firing.
Exactly. Demotion, termination, discipline. The only exception is if there's evidence of unrelated, well-documented misconduct that occurred either before or during the leave, which would have led to that action anyway, regardless of the FMLA leave.
So the leave itself can't be a reason. Got it. And what about benefits, like health insurance? Do those continue during FMLA leave?
Yes, very important point. Section 825.209 addresses the continuation of benefits. During FMLA leave, an employee's group health insurance coverage must be maintained under the same terms and conditions as if they were actively working.
Same coverage, same cost share.
Exactly. The employer continues to provide coverage, and the employee generally continues to pay their portion of the health insurance premiums. So, for you as an employee, you don't have to worry about losing your health coverage just because you're on FMLA leave.
That's a significant protection for sure. What happens, though, if the employee decides, not to return to work after their FMLA leave ends?
That's a possibility. In that situation, the employer may be able to recover the premiums they paid for the employee's health insurance coverage during the leave period.
They can ask for that money back.
They potentially can. However, there are important exceptions. For instance, if the employee's failure to return is due to the continuation of their own serious health condition, or the condition of the family member they were caring for, or other circumstances beyond their control, the employer likely can't recoup those premiums. It really depends on the specific circumstances.
Okay, so it's not automatic. Navigating all of these interconnected rules must present some real challenges for employers. What are some of the common pitfalls you see companies encountering with FMLA compliance?
Oh, definitely. Several challenges frequently arise. One significant issue is inadequate record keeping.
Just not tracking things properly.
Yeah. Without a robust system to accurately track FMLA leave usage, the various notice deadlines, medical certs, employers can face real legal issues if they can't demonstrate compliance later on. Another common pitfall is misclassifying employee eligibility.
Getting that initial step wrong.
Exactly. Incorrectly determining whether someone meets the criteria for tenure, hours worked, or worksite employee count. This can lead to unlawfully denying valid leave requests.
That makes sense. Keeping track of all that data must be crucial. What are some other areas where employers often stumble?
A lack of training for managers and supervisors is a major risk.
The frontline folks?
Yep. If those managers aren't educated on how to recognize situations that might trigger FMLA eligibility, or they don't understand the correct procedures for communication and documentation, it can unfortunately lead to claims of FMLA interference or even retaliation.
Because a manager says the wrong thing, maybe.
Precisely. Or fails to escalate it to HR properly. Also, timing violations related to providing those required notices are quite common. Missing those strict deadlines can inadvertently infringe on employee rights. Often, implementing some level of automation for these deadlines can be a significant help.
So given these potential challenges, these pitfalls, what are some best practices that HR professionals can implement to ensure smoother FMLA compliance?
Good question. There's several key strategies. First and foremost, standardize all FMLA-related documentation.
Templates and checklists.
Exactly. Clear templates for all notices, certification forms, internal communication processes. Second, provide comprehensive training to all supervisors and managers. Teach them how to identify potential FMLA triggers, even from seemingly offhand comments, and make sure they know their role, which is primarily to escalate to HR.
Get HR involved early.
Right. Third, conduct regular, ideally annual audits of your leave records and FMLA policies. Make sure they're up to date with any regulation changes and are being applied consistently.
Check yourself regularly. Makes sense.
Fourth, when FMLA leave is foreseeable, like for a planned surgery or birth, initiate communication with the employee as early as possible. Discuss the process, gather necessary info, confirm everything in writing.
Proactive communication.
And finally, it's absolutely essential to protect the privacy of all employee medical information related to FMLA leave. Keep these records separate from general personnel files, secure, and in compliance with both the DEMERO and FMLA confidentiality rules.
Those sound like very practical and actionable steps for employers. Now, what happens if an employer does end up violating the FMLA? Who enforces this, and what are the potential consequences?
The Wage and Hour Division, or WHD, of the U.S. Department of Labor is the federal agency tasked with enforcing FMLA.
Okay, the DOL.
Yeah. Employers found to be in violation can face significant liabilities. These can include having to compensate the affected employee for any lost wages, salary, benefits they were denied.
Back pay, basically.
Yes, plus potentially interest on those amounts. Furthermore, courts can order equitable relief, like requiring the employer to reinstate the employee to their former position.
Get the jerk back.
And finally, employers may be held responsible for covering the employee's attorney's fees and court costs. It's crucial to understand that even unintentional violations can lead to these kinds of legal and financial repercussions.
Wow. So even mistakes can be costly.
Absolutely.
Yeah.
Which really underscores the importance of proactive and thorough compliance efforts.
It definitely sounds like something best avoided through careful adherence to the regulations. Now, in today's world, how can technology help employers manage FMLA compliance more effectively?
Oh, technology offers significant advantages here. It can really streamline FMLA administration. Many HR departments are now using dedicated leave management software.
Specific software for this?
Yeah. It automates the complex calculations, tracks those critical deadlines for notices, manages intermittent leave tracking, which can be a real headache manually.
I can imagine.
Self-service portals empower employees to submit requests and upload certifications securely, which can speed things up and improve accuracy.
Make it easier for employees, too.
Right. And compliance dashboards can give HR real-time visibility into all open leave cases, flag potential issues, generate reports for auditing. Ultimately, these tools help minimize human error, ensure consistent application of policies, and create those important legally defensible audit trails. Makes the whole compliance process much more manageable.
It sounds like technology can be a real game changer for employers in this area, reducing risk and burden. So as we bring this deep dive into the core of FMLA based directly on the eCFR to a close, what is the key message you want our listeners to take away?
I think the fundamental takeaway is that understanding and adhering to FMLA regulations, as outlined in the eCFR, isn't just about legal obligation. It's really a crucial aspect of fostering a supportive and legally sound workplace. It's about recognizing the needs of your employees and ensuring their rights are protected during these really critical life events.
And just to quickly recap for everyone listening, we've explored the why behind FMLA, that goal of balancing work and family. We broke down who is eligible based on employer size, how long you've worked there, and recent hours. We covered the 6 specific reasons that qualify for leave, from welcoming a child to serious health conditions and military needs. And importantly, the core responsibilities employers have: giving those timely notices, handling medical certs properly, ensuring job restoration, and maintaining benefits like health insurance. So for you listening, understanding these core principles provides hopefully a significant shortcut to grasping this vital area of employment law without feeling totally overwhelmed by the dense regulations.
Exactly. And as we think about the bigger picture, I'm kind of reminded of the idea that while compliance, following the rules, is absolutely essential, building a truly supportive workplace goes beyond just that. It involves, a commitment to fairness and understanding the real challenges employees face.
Yeah.
Perhaps you can reflect on how the principles we've discussed today can inform not just your understanding of the law, but also your approach to creating a more, human-centered work environment in your own context.
That's a powerful thought to end on. Not just the letter of the law, but the spirit too. And for those of you who want to explore this further, we definitely encourage you to maybe delve into specific sections of the eCFR that are most relevant to you, or perhaps consider how FMLA interacts with other important employment laws like the ADA or state leave laws. There's always more to learn, and we hope this deep dive has provided a solid foundation.
Thank you, viewers, for watching. If you found this video helpful, don't forget to hit that like button and share it with your colleagues. And if you haven't already, make sure to subscribe to the channel by clicking that subscribe button below so you never miss out on valuable insights. I'm Brian Edmonds, signing off. See you in the next one.